This is Speaking Freely, and I'm Floyd Abrams. And I thought what we talk about today is just how different we are as a free country, as a country that treasures freedom of speech, from other free countries that also treasure freedom of speech, but not quite as legally protected as here. Let me give you some examples. If you think of the subject of what one can say or what one gets in trouble for saying, if you engage in a sort of defamation of people, groups of people, we have a very different legal system, legal approach here because of the First Amendment than other very democratic countries that also treasure free speech. But in areas like this, not as much. In Canada, for example, they had an interesting case just a few years ago about a man, I guess you'd call him a religious zealot, who was furious at the idea that in Saskatchewan, they were about to teach about homosexuality in high school. He was furious. And he wrote material on paper, typed it out, big, bold type, printed it out, and brought it, old-fashioned way, to mailboxes around Saskatchewan. And what did he say? He denounced the school board. He denounced them for being, soft, too easy, too supportive, he said, of homosexuality. You're going to teach buggery, he said. You're going to persuade young people to engage in homosexual misconduct. And as he went along, he denounced homosexuality itself and people who were gay in very strident, deeply offensive terms. Canada has a hate speech law. They call it hate speech. And it's designed to protect people in accused groups. In this case, gay people. In other cases, people of color, Jewish people, other people whose whole group of which they're a part of has been defamed through the years. And Canada makes it a crime to do so. So when this man delivered mailbox to mailbox his denunciation of the school board, and people found out who it was from, he was arrested. He was tried, and he was convicted of the crime of engaging in hate speech of the sort that I've just described. Now think of an American case. We had a case just a few years ago in which the group called the Westboro Baptist Church, it is more a family than one would think of as a church, but they certainly characterize themselves as a church, engaged in a deeply offensive, I'm understating it, deeply offensive practice of attending the funerals of American young men and women who had been killed in action, and carrying signs with them which generally denounced gay people, regardless, incidentally, of whatever the sexual orientation was of the dead soldier. So they did that at the funeral of a young man who had been killed in action in Iraq. And they brought their signs. And the signs were coarse, hate-filled signs. Signs using words like fags. Signs using other language denigrating anyone, everybody that was gay. And saying this was God's will, or sometimes saying in effect, God, this is not my language, God is stupid because gay people were around. The father of the deceased boy sued. Now, I should be very clear that the place that they stood was a place where the police said they could stand. Not inside a church, not right outside, but in an area 1,000 feet away where the police had set aside an area for people that just wanted to look at the people coming in and out of the church or otherwise. And so the father brought a lawsuit for, in essence, the harm done, the psychic harm done to himself for seeing his son's funeral, and in effect his son as well, defamed. And the question when this case reached the Supreme Court was, well, is this sort of thing actionable? Is there a lawsuit which can be brought with respect to that speech? And the Supreme Court said no. The opinion of Chief Justice John Roberts said in substance, like it or not, pained or not, we protect free speech. And this was the speech of someone objecting to something a school was going to teach or teach about, however inaccurately and offensively he described it. That would be the Canadian case. In this case, simply at a funeral, the signs themselves were, of course, violative of any notion of protecting against hate speech. And the Chief Justice, in his opinion, said, in effect, that's why we protect it. We protect bad speech as well as good, offensive speech as well as inoffensive speech. We reject the notion, the First Amendment rejects the notion that sort of speech could be actionable. In fact, some of the speech dealt with the Army itself, having gay people in the Army. But whether it was that itself or the broader defamation of gay Americans, Chief Justice Roberts wrote that this is protected speech. And in general, that is the side of this fight, the fight between sometimes people who engage in group defamation, that's what it is, and the other side being, people are allowed to sound off, to say even deeply offensive things. One sees this difference between American law and foreign law all over the place. In England, opponents of people with Islamic backgrounds and beliefs coming to England had a big sign of the World Trade Center aflame, and with words under it saying, "Keep Islam people out." In England, that was a crime. He went to jail. And calling it a crime was something that an international court designed to protect free speech and the like agreed with English law was something that could be made illegal and could be made criminal. Here, that would be, I would say, even an easier First Amendment case than the one I mentioned a moment ago, because here the language, the offensive, the outrageous language, directly related to a public issue, who gets to come to England and who not. And there have been a number of cases in England and in Western Europe in which language aimed at Muslims and aimed broadly with signs and the like, was held to be not protected by principles of free speech because of the harm it could do. That same distinction is one we see in a variety of other areas. Privacy, for example. We protect privacy up to a point, but more often than not, if the complaint is simply, what you wrote about me was too intrusive, our law, because of the First Amendment, leans in the direction of allowing free speech. But in a case in Finland, very interesting case in Finland, and the Scandinavian countries have historically been very protective of freedom of speech. But in that case, the Prime Minister of Finland had had an affair with a woman who lived with him and his children by a marriage he had had. She had lived in part in the very place where the Prime Minister lived. And when their relationship ended, she wrote a tell-all book, talked about their relationship, talked about in rather veiled terms, but nonetheless clear enough so anyone would understand, a sexual conduct that they'd engaged in. Talked about his children. He brought a lawsuit. Indeed, he brought it in the name of Finland. So here was this case brought in the name of a country against an individual who had written that sort of book. And the Finnish court held, and again, the European court that exists to protect freedom as a matter of law throughout Europe, that sort of speech was unprotected because of privacy. That the whole notion of privacy, the court said, was such as to be violated when the whole purport of the book, everything the book was about, was in essence a violation of the Prime Minister's privacy. That would be an impossible position for an American president, for example, to take. Bill Clinton, by way of example, Monica Lewinsky, all of that scandalous material of more than a few years ago now, the idea, that Clinton could have sued or would have sued, or the courts would have entertained a lawsuit if she had written the book that she never did write. It's just another example of how different the approaches are between our protection of free speech and the very real protection of free speech elsewhere. I guess I first noticed this personally when I was working as a 34-year-old lawyer on what became known as the Pentagon Papers case. Secretary of Defense Robert McNamara, during the war in Vietnam, had asked that a document be written setting forth how we got into this endless war, which we seemed unable to win except by means we would not use, atomic weapons or anything like that. And so we asked people in the Defense Department to prepare a document, just taking it from the beginning. Where did this all start? What happened next? What happened next? It was a 7,000-page report that was finally released to the Secretary of Defense. Every page on it, every single page, had the words top secret, sensitive. And those words are, in legal terms, words of art. What they mean is, translated into the language we would use with each other, that there would be such a high level of danger to the public if this were published or otherwise made public that it should not or properly could be kept secret. So when the United States government went to court with respect to what became known as the Pentagon Papers case, they said just that. We're in the middle of a war. There are American prisoners of war being held, wherein they didn't quite say secret, but constant contact with our allies with respect to the war. Every aspect of this document, the government said, was secret. Well, that document had by that point leaked to the New York Times. And the Times had taken the advice of not only its journalists about what to publish, but the advice of former Defense Department people, former intelligence people, that there was nothing in what the Times was going to publish which would genuinely harm national security. And so that case ultimately reached the Supreme Court, and the Supreme Court said in substance, there's nothing that threatens the First Amendment more than what's called a prior restraint, a limitation in advance on what somebody or some entity could print or publish or say. And the court said by a 6-3 vote that the government had not demonstrated sufficiently that publishing this material would do the sort of harm that would allow a court order barring it from being published. The decisive opinion, the opinion of the two justices who made up the six, Justice Stewart and Justice White, made very clear that they thought publication would do harm, but that nonetheless, the First Amendment was so antagonistic to the notion of prior restraints on speech. And since because the government had not shown with any sureness that real bad harm would occur as a result of publication, that they went along for that reason with what became the majority in this 6-3 vote. By chance, I spent some time in Europe and Israel not long after that case, and I was sort of struck by the fact that every journalist that I talked to in England, Switzerland, Israel, all were stunned by the result. All thought conclusively, in their view, that their governments, their courts, would not have allowed it to be published. And all rather admiringly, but still surprised, saying that it must be your First Amendment that gives that sort of protection. Now again, to be clear, the court did not say anybody could publish anything relating to national security, and for sure, the court will not stop it. And the court also made clear they weren't talking about whether a criminal punishment could be imposed. But nonetheless, the finding of the court in this really important case was that the government had failed to meet a very, very heavy burden of proof before any sort of order would be entered against the press. Let me conclude with this. When the Constitution was written, it wasn't at all clear what it would say. In fact, it wasn't even at all clear what it would be about. The Articles of Confederation after the Revolutionary War had made the different colonies, the states now, allies together, legally together in some respects. but there was almost no power in the federal government at that time. There were no federal coins. Every state had its own. There was no federal army. No foreign policy decisions could be made unless all the states agreed. And so there was a shared sense that there was a need to have a federal government, a national government, which would have certain powers. And they sat and they wrote out in the Constitution broadly what those powers would be. And initially, there was no Bill of Rights. Initially, there was nothing saying the government can't do this or that or something else. It was simply how the government would be structured. There would be a president. He or she would serve for 4 years, et cetera, et cetera. But there were no bars. There was no negative things saying, and the government can't do this. And people like Alexander Hamilton back then argued that's the way it should be. We're not giving this new national government powers to limit speech or religion or the like. They don't have the power, so why do we have to say that they don't have the power? In fact, Hamilton wrote, if we start listing the things this new federal government can't do, we'll go on forever, or we'll leave things out, or people hundreds of years later won't know what we had in mind by what we're doing. Hamilton wrote, the Constitution itself is a Bill of Rights. But opponents on the other side, led in part by Jefferson, who was then the U.S. ambassador in France, took the opposite position. Jefferson wrote, it astonishes me to think that our people would sign on to a document of this sort which does nothing by way of protecting freedom of religion, freedom of speech, freedom of the press, or the like. And Jefferson and many others finally carried the day, and so we wound up with the First Amendments, of which the First Amendment that was ratified was, of course, the one that begins, Congress shall make no law abridging, and then after dealing with religion, they turn to abridging the freedom of speech or of the press. And that's why we have legal protection. That's why the legal protection has been interpreted very broadly through the years by the Supreme Court in protecting free expression. None of this means that our foreign allies that believe in free speech and privacy, for example, don't therefore believe in free speech because we provide more protection. What it does mean is that we have decided, our courts have said that the First Amendment has decided that there is a higher level of protection for free speech and free press in the United States than is true, basically, anywhere else in the world. That was the case, that is the case, and I, for one, hope it continues to be the case. Thank you very much.